The Ventura Superior Court Family Law Self-Help Center presents Starting Your Divorce or Legal Separation in California. This video contains general legal information only and is not intended to constitute legal advice. The information and forms in this video will not cover petitions for summary dissolution or joint petitions for dissolution. For assistance with these types of cases, please contact the Family Law Self-Help Center directly. If you're experiencing domestic abuse, your safety should be your top priority. If you're in immediate danger, call 911. The Ventura County Family Justice Center offers a variety of safety services including restraining orders and creating a safety plan. You can reach the Family Justice Center at 805-652-7655. In California, you can get a divorce by starting a court case. A divorce is also called dissolution of marriage. No one has to prove someone did something wrong to cause the divorce. This is called a no-fault divorce. You can get a divorce even if the other person doesn't want one. A legal separation case has a similar process to the divorce. If you can't or don't want to get a divorce, but you want court orders regarding your property, finances, and children, you can ask for a legal separation. In a divorce, either you or your spouse has to have lived in California for the past 6 months and in your current California county for the past 3 months. But in a legal separation, only one of you must live in California and there's no time requirement. In a divorce, there's a 6-month waiting period. The earliest a couple can become single is 6 months from the day the other spouse was served with divorce papers or responded in court. In a legal separation, there is no 6-month waiting period. Finally, a divorce restores the parties to their single status. In a legal separation, they remain married persons. In both divorce and legal separation cases, the court can make orders about the division of your property, who will be responsible for paying debts, and spousal support. And if the parties have minor children together, child custody and visitation, and child support. If either or both parties use a lawyer, the court can make an order about who will pay their fees. There are important legal issues you need to understand when you start a divorce or legal separation. Let's start with the date of marriage. The date you legally married, found on your marriage certificate. Date of separation. There's a 2-part test to determine the date of separation. The first factor is when one party communicated to the other that they want to be separated. The second factor looks at whether you still acted like a married couple or if you started acting like you were separated. The court considers all your actions, like if someone moved out, stopped sleeping in the same room, stopped going to sporting events, church, or holding yourself out as a married couple to the public. The court will take an objective view of your actions and consider, what do married couples normally do? And did you stop acting like a married couple to determine the date of separation? The date of separation determines the length of your marriage, the day you married until the day you separated. This date can impact issues in your case like property division and spousal support. Part of your case will involve dividing your property and debts. Property is anything you can buy, sell, or has value. For example, a house, car, or furniture. It's also things like a bank account, pension, 401k, or stocks. The date of marriage and the date of separation are important because those days help to determine whether property and debts are to be considered part of the community or are separate. The general rules for characterizing property and debts as community or separate are: community property is what you own or owe together during your marriage. It does not matter if a debt is only in the name of one spouse. If it was incurred during the marriage, it is generally considered community. Separate property is what each of you own or owe individually before you married or after you separated, and any gifts or inheritance either before or during the marriage. Property can be mixed together as part community and part separate. For example, a 401k retirement account could be considered part community and part separate. These are general rules. There are several exceptions to these rules, and the division of property and debts can be complicated, especially if you have mixed assets or a lot of assets or debt. Before you sign any agreement that divides up your property, you may want to consider getting legal advice from a family law attorney. Spousal support, also known as alimony, is a court-ordered payment from one spouse to help cover the other's monthly expenses. Spousal support is more common when the marriage was long or one person earns significantly more than the other. The judge can make 3 types of spousal support orders. Order amount of support that one spouse pays the other. Reserve spousal support. This means the court is not ordering support now, but it could do so in the future. Or end or terminate the court's ability to make any spousal support order in the future. Please check with the Family Law Self-Help Center for detailed information on spousal support factors the court considers. Child custody refers to the rights and responsibilities of the parents for taking care of their children. There are 2 types, legal and physical. Legal and physical custody can be shared, joint, or only to one parent, sole. Legal custody. Who makes important decisions for your children, like healthcare, education, welfare? Examples of important decisions are school or childcare, religious activities, and all medical decisions including mental health issues, except in emergency situations. Joint legal custody means both parents share the responsibility for making these important decisions. Sole legal custody means only one parent has the responsibility for making these important decisions. Physical custody is who your children live with most of the time. Joint physical custody does not have to mean a 50-50 timeshare between the parents. Joint physical custody can mean that the children spend a significant amount of time with each parent. This can vary depending on the best interests of the child and the parenting schedule. Sole physical custody usually means the children will live with one parent most of the time while the other parent has designated visitation. Sole physical custody does not always mean one parent has 100% of the custody with no visitation given to the other parent. Visitation is a schedule of time each parent spends with the children. A visitation schedule may include a general or specific schedule of days, times, weekends, holidays, vacations, transportation, pickup and drop-offs, limits on travel, counseling, treatment services, and other details. If there are concerns about the children's safety and well-being, the court could order visits be supervised or no visitations be ordered. In Ventura County, if you cannot reach an agreement on custody or visitation, you will have to go to court. Before your court date, the court will refer you to Family Court Services for a special type of mediation called Child Custody Recommending Counseling, CCRC, which is also referred to as mediation. In CCRC, parents work with a neutral professional called a Child Custody Recommending Counselor. During CCRC, you will have the chance to discuss the unique needs of your child, and the recommending counselor will help you explore options that work both for you and the other parent. If you reach an agreement in CCRC, the recommending counselor will help you put your agreement in writing and submit it to the court for approval, and it will become the court order. If you are unable to reach an agreement, the recommending counselor will make a written recommendation to the court about custody and visitation. The judge will review the recommendation and make an order that aligns with the child's best interests. By law, both parents must support their minor children. Parents must share the financial responsibility for raising their children. Child support is the amount of money that a court tells a parent to pay every month. This money is to help pay for the children's living expenses. In California, child support is calculated by a guideline set by law. The guideline looks at how much money each parent makes, how they file taxes, how much time they spend with the children, and other factors. There's a free online child support calculator you can use to calculate child support. A link for the guideline calculator provided by California Child Support Services is available in the video description below. You can receive assistance with each step from the Family Law Self-Help Center. Here's an overview of the process. Step 1. Complete the forms. Step 2. File the forms with the court. Step 3. Serve the filed forms on the other parent. The forms you will need can be found in the form packets on the court's website under the Court Resources tab. The form packet also has a link for an online form preparation program that can help you complete the forms. After you create your account, the forms interview will look like this. This program does not file the forms for you. Once your forms are completed, it's now time to file with the court to start your case. To file, you will have to pay a fee or submit fee waiver forms. The forms are filed at the Family Law Clerk's office located in room 208 on the second floor of the Ventura County Superior Court at 800 South Victoria Avenue in Ventura, California. Please check the court's website for fee information, hours of operation, and appointment information for the Family Law Clerk's office. You'll need to have your spouse served with a file-stamped copy of the forms, along with a blank response and declaration under UCC-JEA if applicable. There are rules about who can be the server. It cannot be you, and they must be at least 18 years old. If your spouse lives in California, personal service is required. Personal service means that the server must hand-deliver a file-stamped copy of the forms and the blank forms personally to your spouse. If your spouse does not live in California, personal service or mail service with return receipt is allowed. For mail service, your server mails a file-stamped copy of your forms and the blank forms to your spouse with return receipt requested. The post office will send you a signed receipt, typically a green card, of your spouse receiving the forms after it's delivered. This will need to be attached to your proof of service. After the forms have been served, the server must complete the proof of service form. You will then file this form with the clerk of the court. Thanks for watching. Remember, you are not done. There are additional steps to complete your case. The Ventura Superior Court Family Law Self-Help Center is here to assist you with the process. You can reach us by email, phone, appointment, or webinar. We are here to help you every step of the way.